Ms. Bacod was even adamant about the zonal valuation as she declared at the hearing on the 22nd of September 2009 that if she were to issue another certification, she would use the same zonal valuation for the Masaito lots. Thus, Mr. Francisco, may I quote, but if you are to make another certification and you were asked for the zonal valuation of San Dionisio, Sucal Road, what will you state? Ms. Bacod answered, I will state the same facts as contained in the same certification. Mr. Francisco, which is, Ms. Bacod, that the zonal value of the property will still be 30,000 pesos per square meter. Mr. Francisco, even if that is not found in the revised zonal valuation 1998, yes, because in this page 9 of San Dionisio, even if the zonal value of Don Antonio Avenue, the zonal value is 4,500, it is residential. But we have on page 9, we have commercial residential valuation of 30,000 pesos. And for sure, my basis for classifying this property as commercial is tax declaration presented to us as issued by the assessor's office, classifying the same property as commercial as to its actual use, Your Honor. Interestingly, the said testimony of Ms. Bacod was conveniently ignored in the report. Again, wala po akong kasalanan, Mr. President. Wala pong anomalya sa C-5. Hindi po ako nakinabang. Politika lamang po ito.
With the indulgence of...
Let me just finish. While none of the witnesses they presented accused me of any wrongdoing. Malapit na, Mr. President. I was shocked. And still I'm in shock that the conclusion they arrived at is completely the opposite. In the report, they concluded that I violated the Constitution for my alleged financial interest in the C-5 project, which a senator placed me in a conflict of interest situation. First, I did not author the 2008 GIA, as no senator can be its author since the GIA originates solely from the House of Representatives. Second, it is not true that I did not disclose my financial interest in the companies whose companies will be traversed by MCTEP and the C-5 Road Extension Project. Di po totoo yan. The truth of the matter is that one of my companies even sought the opinion of the DOJ precisely to determine whether or not the validity of the proposed transaction will be affected by the fact that I am its principal stockholder and whether the proposed acquisition will be violating any law or regulation, particularly the Constitution. And significantly, on November 9, 1999, the DOJ, through Justice Serafin Cuevas, rendered an opinion holding that the acquisition by the government of private property for right-of-way purposes does not fall within the constitutional prohibition against the members of Congress having direct or indirect financial interest in any contract with the government. As aptly put by the then Secretary of Justice Cuevas, in the instant case, there is no showing that the principal stockholder of the API or Adelpha Properties Inc. took advantage of his position as a member of the House to enable the API to enter into a contract with the TRB involving the API's property. The transaction arose as a necessary consequence of the government's decision to implement the MCTEP, and for which it became necessary for the TRB to acquire properties for the right-of-way purposes. The API property happens to be one of those that the TRB has identified as necessary for the implementation of the MCTEP. Clearly, the proposed acquisition by the TRB on a voluntary sale and purchase basis of the property of the API for right-of-way purposes does not fall within the subject constitutional prohibition. The said proposal is a mere consequence of the exercise of the TRB of its power to condemn private property for public use, subject to the provisions of existing law in acquiring the API's property through negotiated sale. The TRB was acting in pursuant to law. In sum, inasmuch as the proposed transaction was not sought by the API nor by any of its stockholders, but was initiated by the TRB in view of the importance and urgency on the part of the government to acquire the subject properties of the API, to obviate delay in the continuous implementation and eventual completion of the MCTEC. This department does not foresee situations such as this, that the principal stockholder of a private corporation who happens to be a member of the House of Representatives would be cited as having violated Section 14, Article 6 of the 1987 Constitution, which expressly prohibits legislators from being directly or indirectly interested financially in any contract with the government or any of its subdivisions, agencies, or instrumentalities. Again, the DOJ opinion was conveniently ignored by the committee. Worse, the committee recommends that I return the amount of 6 billion pesos which I allegedly made the people to suffer. Nakakatawa naman ito, Mr. President. Let me state categorically that no government money was wasted in the C-5 project. Not a single centavo. Ni hindi nga na-release yung mga pinag-uusapan natin dito, ni hindi nga binayaran yung right of way. The MCTEC, to Point Toll Road, was not rendered useless by the construction of the C-5 road extension project. Ito pong dalawang proyektong ito are entirely separate, distinct projects. The MCTEC is a toll road which requires payment of toll fees, while the C-5 road extension is a public road which allows free passage to all commuters. In other words, the C-5 road extension is an alternative route to commuters who cannot afford to pay toll fees. The CMCTEP has limited access, meaning it has single entry and single entry exit point, while the C-5 road extension has open accesses, such that through said road, commuters can access various cities and or municipalities. Clearly, by their very nature, it is not difficult to comprehend that the two projects are not mutually exclusive of each other, or that the C-5 road extension is a duplicate of the MCTEP. The construction of the C-5 road extension did not result in MCTEP becoming unnecessary as to require its being discontinued. The truth is, both projects are necessary to decongest the worsening traffic conditions in Parañaque, Las Piñas, and Cavite. Ito pong, bakit naman po? Ito po ay parang yung NLEX at saka yung MacArthur. Dahil meron na pong NLEX, hindi naman pwedeng wag nang gawin yung MacArthur. O yung may MacArthur na, hindi naman pwedeng wag nang gawin yung NLEX. Kailangan po pareho yan. At inuulit ko na naman po. The right of way payments on the MCTEP were not wasted. The roads acquired are still there, owned by the government. Once the TRB shall have found another joint venture partner, the expressway project can continue.